I'm reading Chapter 3 of Torts, Cases and Materials by Prosser, Wade, and Schwartz. Starting on page 98, left off with notes and questions as they relate to Hackabart versus the Cincinnati Bengals, which had to do with an ugly hit that was probably illegal, and I just didn't get through it last night. 1. In notes and questions. Why did plaintiff's attorney sue under a theory of battery instead of ordinary negligent medical malpractice? Should there be recovery if defendant used all reasonable care in the operation? And they're quoting from Rogers versus the Board of Road Commissioners. So I'm wondering if this case actually, this isn't the Bengals case, or is it? No, this is the Moore versus Williams case. When an ear specialist put someone under anesthesia to have the right ear operated on and found out that it was the left ear that needed an operation, and performed surgery on the left ear without the plaintiff's authorization. Number 2, plaintiff. A boy, 15 years of age, was run over by a train and his foot was crushed. When he arrived at the hospital, he was unconscious and bleeding. Defendant, a house surgeon, concluded that immediate amputation of the foot was necessary to save the boy's life. Finding no relatives present, he performed the operation. Is he liable? Why? This I can answer because it has to do with life and limb. So he is not liable since the boy was unconscious and a reasonable person would want to live if it meant life or limb. 3. What if the plaintiff had remained conscious and had insisted on prohibiting the operation, saying that he would rather die than lose his foot? See Malloy vs. Hop Sang. Automobile accident victim arrived at hospital asking that his badly injured hand be treated but not amputated. Construction worker, believing that he saw 666, the sign of the devil, on his hand, cut it off with a power saw. His co-workers rushed him and his severed hand packed in ice to the hospital. A hand surgeon was standing by ready to attempt to reattach it. Patient refused permission, saying it was against his religion. What should the surgeon do? See man who lost hand loses lawsuit. From the Richmond Times-Dispatch in 1997. 4. Medical care providers may act in absence of express consent if 1. The patient is unable to give consent, unconscious, intoxicated, mentally ill, incompetent, and 2. There is a risk of serious bodily harm if treatment is delayed, and 3. A physician has no reason to believe this patient would refuse treatment under the circumstances. See example Kozup vs. Georgetown U Hospital. In the District of Columbia Circuit, 1988, the parents consented to baby's transfusion was not implied simply because it was necessary to save baby's life, where there was no showing that there was no time to seek consent. Stuart Graves vs. Vaughn, Washington, 2007. Father's consent implied as a matter of law, even though he was in nearby waiting room, because there was no meaningful opportunity for a deliberate, informed decision concerning treatment where failure to treat would have meant certain and immediate death of the newborn. 5. The principal case has been regarded for years as a leading case on unauthorized operations, and that's the case we just read. Again, about the ear operation. titled Moore v. Williams in Minnesota, 1905. It is still sound law. Most surgeries performed in hospitals, which have their own rules and standardized practices, including consent forms. In many cases, it has been found that the consent is sufficiently general in its terms to justify the physician in doing whatever the physician believes necessary in the course of the operation. See, for example, Roth v. Hull, State M.O. period, 1944, Baxter v. Snow, Utah, 1931. Does that mean the consent should be as broadly worded as possible? What if an obstetrician who has privileges at a hospital fails to obtain consent for a blood transfusion? The obstetrician would be liable. Would the hospital? Ward v. Lutheran Hospitals and Homes of SOC in America, Inc. of Alaska, 1998. Noting that overwhelming weight of authority holds that hospital does not owe duty to patient to obtain consent for treatment when treatment is under care of independent physician. 6. What if plaintiff specifically insists that the procedure shall go thus far and no further? For example, she consents to an incision and an examination of her stomach under either, but expressly forbids anything more. If a surgeon goes ahead and removes a tumor found there, is he liable? See Scholendorf v. Society of New York Hospital in New York, 1914. What if patient limits her consent to female healthcare providers, explaining that her religious beliefs prohibit her from being seen unclothed by a member of the opposite sex? During surgery, a male nurse sees and touches her as part of proper medical treatment. Liability for battery, ? Cohen v. Smith, Illinois, 1995. Violation of plaintiff's right to bodily integrity by unconsented to touching is the essence of battery. What if the consent form states anesthesia will be administered by a physician privileged to practice anesthesia, and an EMT in training is permitted to do her first intubation on the patient? Mullins v. Parkway Hospital, Inc. Battery claims stated against anesthesiologist but not student EMT who did not know that consent had not been obtained. What if patient about to undergo an MRI limits her consent to particular drugs, Demerol and morphine, because she is concerned about an allergic reaction? The nurse gives her fentanyl. Battery? Duncan v. Scottsdale Medical Imaging, Ltd., Arizona, 2003. Rejecting argument that the patient consented to the administration of pain medicine and therefore the nature of the procedure was the same no matter which drug was used. What if the patient of the procedure was the same no matter which drug? What if a patient withdraws her consent during the procedure? This is Schreiber v. Physicians Insurance Company of Wisconsin, 1999. Withdrawal of consent means the physician must conduct new informed consent discussion. Cannot continue to rely on previously given consent. Coulter v. Thomas, Kentucky, 2000. Withdrawal of consent while medical procedure in progress must be unquestionable response from clear and rational mind, and it must be medically feasible for doctors to stop. May a competent, informed adult refuse medical care or treatment that is necessary to preserve life? Thor v. Superior Court in California, 1993. Right to refuse treatment not limited to those who are suffering from terminal conditions. 8. Brother Joseph Fox, an 83-year-old member of The Marianists, a Roman Catholic order, had previously expressed a desire not to have his life artificially prolonged by extraordinary means of treatment if there was no reasonable hope for recovery. During surgery to repair a hernia, he suffered permanent brain damage due to cardiac arrest. Was his refusal of extraordinary means of treatment, a respirator, still effective after he became incompetent? Matter of Storar. Certiorari denied. This is a New York case, 1981. This issue is resolved in many jurisdictions by statutory provisions for living wills or advance directives, which state the patient's consent and limitations on treatment. 9. When plaintiff refused to consent to a transfusion on religious grounds, the court, in application of the president and directors of Georgetown College, this is the D.C. District Court trying this case in 1964, granted a declaratory judgment to proceed, that with the judge who issued the emergency order, finding the patient felt that it would not be her responsibility if the judge ordered the transfusion. A similar request was denied in re Osborne, where a bedside hearing disclosed that the patient would regard a transfusion under any circumstances as violative of his religious beliefs. See also Stanford Hospital in Connecticut. 1996, patient competent to make decisions entitled to refuse blood transfusion even if that decision is fatal. 10. What happens if healthcare personnel ignore a do not resuscitate order? If the patient or his family has a cause of action for battery, what is the measure of damages? Campbell v. Delbridge, Iowa, 2003, plaintiff entitled to emotional distress damages for unauthorized transfusion. Anderson v. St. Francis St. George Hospital, Inc., Ohio, 1996, where the battery was physically harmless. Plaintiff entitled only to nominal damages, not compensatory damages for wrongful living or wrongful prolongation of life. See also Milani, better off dead than disabled. Should courts recognize a wrongful living cause of action when doctors fail to honor patients' advance directives? 11. In the case of a minor child, consent of the parent is necessary for any medical procedure except in an emergency. Uzowski v. Gaines, Michigan, 1935, 9.5 years old. I guess had a tolensectomy administered without, I guess, the parents' approval. So, what have we learned? We've learned these are called advance directives, and we've learned that they talk about respirators and transfusions. Okay. Still talking about children. A minor, Bonner versus Morin, D.C. Circuit, 1941, 15-year-old has skin graft. A minor, 17 or 18 years of age, however, has been held capable of legally consenting at least to minor procedures. Gulf and SIR Company versus Sullivan in Mississippi, 1929. Smallpox vaccination. But not to major ones. Lacey versus Laird, Ohio, 1956, regarding a nose job. Is consent from a parent necessary to prescribe contraception? The right of mature teenage females to give or withhold consent to abortions is governed by statute in most jurisdictions, and the statutes in turn must fall within constitutional parameters. 12. When a parent refuses on religious or other grounds to allow a hospital to provide medical treatment for a child, courts are likely to grant a hospital's application to overrule the parent if the treatment is for a life-threatening condition, but not if it only will improve the child's comfort or appearance. compare Henry Sampson and New York case approving with Henry Green, Pennsylvania, 1972 disallowing. And lastly, 13, can parents consent on behalf of their child to be a donor in a transplant operation for the benefit of a sibling? See Hart v. Brown, Connecticut, 1972. Can a guardian consent to an incompetence donation of an organ? See Strunk v. Strunk, Kentucky, 1969. Can a parent consent to a child's participation in non-therapeutic research in which there is a risk of injury or damage to the health of the child? Grimes v. Kentucky Krieger Institute, Inc., 2001, and I believe I said Kentucky, but I meant to say Kennedy, and this occurred in Maryland. Does the mother's consent to an abortion prevent the child who is injured by the failed abortion from bringing a personal injury action against the physician? See Van der Vellen v. Victoria. And this is a Wisconsin case in 1993. DeMay v. Roberts is the next case, starting on page 100. This is tried in the Supreme Court of Michigan, 1881. The declaration in this case, in the first count, sets forth that the plaintiff was at the time and place named a poor married woman, and being confined in child bed, and a stranger employed in a professional capacity. Defendant DeMay, who was a physician, that defendant visited the plaintiff as such, and against her desire and intending to deceive her wrongfully, etc., introduced and caused to be present at the house and lying in room of the plaintiff, and while she was in the pains of parturition, the defendant Scattergood, who intruded upon the privacy of the plaintiff, indecently, wrongfully, and unlawfully laid hands upon her and assaulted her. The said Scattergood, which was well known to defendant DeMay, being a young unmarried man, a stranger to the plaintiff and utterly ignorant of the practice of medicine, while the plaintiff believed that he was an assistant physician, a competent and proper person to be present and to aid in her extremity. The evidence on the part of the plaintiff tended to prove the allegations of the declaration. On the part of the defendant's, evidence was given tending to prove that Scattergood very reluctantly accompanied Dr. DeMay at the urgent request of the latter, that the night was a dark and stormy one, the roads over which they had to travel in getting to the house of the plaintiff were so bad that a horse could not be rode or driven over them, that the doctor was sick and very much fatigued from overwork, and therefore asked the defendant Scattergood to accompany and assist him in carrying a lantern, umbrella, and certain articles deemed necessary upon such occasions, that upon arriving at the house the plaintiff, the doctor knocked, and when the door was opened by the husband of the plaintiff, DeMay said to him that I had fetched a friend along to help carry my things. He, plaintiff's husband, said all right, and seemed to be perfectly satisfied. They were bid to enter, treated kindly, and no objection whatever made to the presence of defendant Scattergood. That while there, Scattergood, at Dr. DeMay's request, took hold of plaintiff's hand and held her during a paroxysm of pain, and that both the defendants in all respects throughout acted in a proper and becoming manner, actuated by a sense of duty and kindness. Dr. DeMay therefore took an unprofessional young unmarried man with him, introduced and permitted him to remain in the house of the plaintiff when it was apparent that he could hear at least, if not see, all that was said and done, and as the jury must have found under the instructions given, without either the plaintiff or her husband having any knowledge or reason to believe the true character of such third party, it would be shocking to our sense of right, justice, and propriety to doubt even but that for such an act the law would afford an ample remedy. To the plaintiff, the occasion was a most sacred one, and no one had a right to intrude unless invited or because of some real and pressing necessity, which it is not pretended existed in this case. The plaintiff had a legal right to the privacy of her apartment at such a time, and the law secures to her this right by requiring others to observe it and to abstain from its violation. The fact that at the time she consented to the presence of Scattergood, supposing him to be a physician, does not preclude her from maintaining an action and recovering substantial damages upon afterward ascertaining his true character. In obtaining admission at such a time and under such circumstances without fully disclosing his true character, both parties were guilty of deceit, and the wrong thus done entitles the injured party to recover the damages awarded after sustained from shame and mortification upon discovering the true character of the defendants. Judgment for plaintiff affirmed. Goodness, there's a lot of notes related to this case. Let's get to them before we can go to self-defense. Notes and questions. Number 1. The court says that the plaintiff consented to Scattergood's presence, supposing him to be a physician, and that the defendants introduced him without fully disclosing his true character. In order for a consent to be valid, how much does defendant have to disclose? What if the plaintiff asks no questions? Under what circumstances can consent be assumed? A breast cancer patient on a routine visit to her oncologist office is shown into a private examining room. Her doctor arrives accompanied by another man who is introduced as someone who is following his work. She says nothing. Following her doctor's instructions, she disrobes and he examines her breast and lower abdomen on the other man in the other man's presence. As she leaves the office, she asks the receptionist who the other man is and is told he is a drug salesman. Consent. This is quoted from Sanchez-Scott v. Alza Pharmaceuticals, California, 2001. Because true status of drug company representative was not disclosed to patient, no consent was implied by failure to object. Which means that this case was a persuasive case, probably in that holding. 2. Defendant calls on plaintiff, a woman with an artificial leg in her house, representing himself to be a doctor referred by the company that made her leg. He induces her to remove her dress, expose her person, and to permit him to touch her. He is in fact a doctor, but of theology. Battery, and this is questioned in Commonwealth v. Gregory, Pennsylvania Superior Court, 1938. Defendant gives plaintiff some chocolate candy which contains an irritant poison. In ignorance of this fact, plaintiff eats the candy and is made ill. Is there liability for a battery? Commonwealth v. Stratton, and that's in Massachusetts in 1873. Defendant represents himself to be a licensed physician, but he is not. Taylor v. Johnson, Alaska, 1999. Battery claim may lie if person falsely claiming to be a physician touches patient even for the purpose of providing medical treatment. On the effect, in general, of fraud and mistake on consent, see Restatement Second Torts, Section 892B. 3. Suppose that A consents to sexual intercourse with B in ignorance of the fact that B has a sexually transmitted disease. A contracts the disease. Has she an action against B? See Kathleen K. v. Robert B. of California, 1984. Crowell v. Crowell, North Carolina, 1920. DeVal v. Struck, Texas, 1936. A woman consents to sexual intercourse with a man only after he asserted her that I can't possibly get anyone pregnant, knowing that the statement was false. She then suffers an ectopic pregnancy and must undergo surgery which saves her life but makes her sterile. Liability. Question. Barbara A. v. John G., California, 1983. Does it make a difference if he also does not know? See McPherson v. McPherson, Maine, 1998. No liability because husband who infected wife with venereal disease neither knew nor had reason to know that he was infected. A. Wife consents to sexual intercourse with her husband in ignorance of the fact that he is having an affair. After learning of the affair, she sues him for battery, claiming that her consent was obtained by fraud. Liability. Neal v. Neal, Idaho, 1994. I'd like to know the answer to that without having to look it up. 4. Law professor agrees to appear in the dunking booth at a law school fair. She was told that the proceeds would be donated to a fund to provide debt reduction for students who embark on public interest careers, but later learned that the students spent the money on a fancy graduation reception for their parents' consent, valid ? Consent induced by fraud or misrepresentation as to a collateral matter, rather than fraud as to the essential character of the act itself, will not invalidate consent. See Restatement Second of Torts, Section 55 and 57. Five, plaintiff consents to an operation under a general anesthetic only on condition that her own physician is present during the operation. He was not present. Is the consent vitiated? And that's Pugsley v. Prevet of Virginia, 1980. What is the effect of allowing a resident physician to perform the operation under the supervision of a designated surgeon? Suppose the designated surgeon is not present at all. Informed consent. The doctrine of informed consent requires a physician or surgeon to disclose to the patient the risks of proposed medical or surgical treatment. If she does not do so, she may be liable when injury results from the treatment. In early cases, the liability was placed on the grounds of battery by analogy to DeMay v. Roberts, and the cases in the preceding notes. Among the cases so holding have been Bang v. Charles T. Miller Hospital of Minnesota, 1958, Gray v. Grunegal, Pennsylvania, 1966. Around 1960, the failure to disclose a risk began to be treated as a breach of the doctor's professional duty and hence as a matter of negligence. The cases now generally proceed on that basis. And the matter is therefore treated in Chapter 4, Negligence. When the physician exceeds the boundaries of consent, the matter is still treated as battery as set forth in Moore v. Williams. 7. Note that most of the consent induced by fraud cases involve battery. What if the underlying tort is trespass? Compare these two cases against ABC, which broadcast primetime live. Plaintiff, an ophthalmic surgeon who owned several clinics, was approached by a producer, Primetime Live, and told the show was doing a segment on cataract operations. The producer told plaintiff that the segment would not involve ambush interviews or undercover surveillance and would be fair and balanced. Plaintiff cooperated by permitting film crews and interviews of doctors, patients, and technicians at his clinic in Chicago. Unbeknownst to plaintiff, the producer also had dispatched 7 undercover test patients equipped with concealed cameras to other clinic locations owned by plaintiff. The resulting show was very critical of the clinics. Plaintiff sued for trespass, claiming the consent was given to the 7 test patients with concealed cameras was induced by fraud. Liability ? Desnick v. American Broadcasting Company. And this is Illinois, 1995. No trespass because not an interference with the ownership or possession of land. Plaintiff, the Food Lion grocery store chain, was the target of a Primetime Live expose on meat handling. This was actually in our legal writing final. Employees of ABC created false identities and applied for work at several Food Lion stores. While working for Food Lion, they filmed various activities with hidden cameras. Food Lion sued for trespass, claiming its consent to the ABC employees' presence in the deli and meatpacking departments was obtained by fraud. Food Lion Inc. vs. Capital Cities ABC Inc. That's the Fourth Circuit Court, 1999. Applying North and South Carolina law, jury verdict of trespass was affirmed. So this was a trespass obtained by fraud. Alright. Reporter posing as student. Oh, and so also see Copeland vs. Hubbard Broadcasting Inc., Minnesota, 1995. Reporter posing as student interested in observing veterinarian liable in trespass to pet owners who allowed her in their home to observe. For a discussion of the invasion of privacy claims in these cases, see Chapter 18, Privacy. 8. Plaintiff is in a bar so intoxicated that he does not know what he is doing when he agrees to Indian wrestle with defendant. Is this valid consent? See Hollerud v. Malamus, Michigan of 1969. Consent ineffective if plaintiff incapable of expressing rational will. 9. Plaintiff consented to participate in a prize fight, an illegal activity in that state. He died as a result of a blow received in the fight, and his estate filed a battery claim against the other fighter who demurred on the basis of consent. Is consent to an illegal act of valid consent? Hart v. Giesel, Washington, 1930, recognizing split of authority among jurisdictions as to whether consent to an illegal act is valid consent. Janelsons v. Button, Maryland, 1994, is the same. The question of when plaintiff's consent should be invalidated because defendant violated a criminal statute may depend on several considerations. A. The policy of denying compensation to an intentional wrongdoer who himself may have committed a crime and been injured as a result of it. B. The effect of deterring him and others like him by denying him recovery if he gets hurt. C. The effect of potential liability in deterring defendant and others like him. D. The fact that plaintiff has, after all, been intentionally battered by the defendant. And E. The policy expressed by the maxim. In pari delicto portior est conditio defentis. The equal guilt, the position of the defendant is the stronger. And so, these are all elements that invalidate consent if the defendant violated a criminal statute. There's like an A, B, C, D, and E. That's 5 elements. Let's reread them. A, the policy of denying compensation to an intentional wrongdoer who himself may have committed a crime and been injured as a result of it. And B, the effect of deterring him and others like him by denying him recovery if he gets hurt. C, the effect of potential liability in deterring defendant and others like him. D, the fact that plaintiff has, after all, been intentionally battered by the defendant. And E, the policy expressed by the maxim, which is in equal guilt, the position of the defendant is stronger. Eden states that generally recognize the validity of consent to an illegal act will not deny recovery to those whom the statute making the conduct illegal was designated to protect. For example, plaintiff, a 15-year-old girl, consents to intercourse with a 50-year-old man in this state with criminal penalties for men who have sexual relations with children that age. Most courts have held plaintiff's consent to be ineffective. See Gaither v. Meacham, Alabama, 1926. A competent adult woman, however, cannot maintain an action for her own seduction, even if intercourse between unmarried adults is illegal in the state. See Rouse v. Creech, North Carolina, 1932. Defendant provides plaintiff's decedent with sleeping pills, knowing he intends to use them to commit suicide. The state's criminal law prohibits both aiding and abetting suicide and attempted suicide. Schwartz, Civil Liability for Causing Suicide, a Synthesis of Law and Psychiatry, was written in 1971. Evaluating the factors set forth above suggests that a claim should be allowed. What family members of those who commit suicide using the Kevorkian suicide machine have a cause of action against Dr. Kevorkian? So there's a section titled Self-Defense and Defense of Others before defense of property and our next case.